The fundamental problem is the risk of bias. The party with exclusive power to appoint the arbitrator is naturally incentivized to choose someone who will benefit them or favor them. Hello, friends. Today we are going to discuss a case which is going to be a game changer for all the financial institutions, government contractors, and basically any person who uses an arbitration clause in their contract. We are talking about Supreme Court's definitive ruling on unilateral appointment of arbitrators in the case of Central Organization for Railway Electrification versus ECI SPIC. The Supreme Court has finally cleared the law on unilateral appointment of arbitrators and the validity of such clauses. So without wasting any time, let's take a dive into the judgment. Before we start the video, if you have not subscribed to the channel yet, please hit the subscribe button. Let's start with the video. So let's set the scene. For years, it was a common practice for large corporations, financial institutions, government bodies to have a standard clause in their contract. This clause gave them the power to appoint a sole arbitrator if any dispute arose. Sometimes the situation would be such that they would provide a small panel of arbitrators to the other party from which they could choose an arbitrator, but the panel would be decided by the person drafting the contract. This, of course, was very convenient for the financially stronger party. So, what's wrong with this picture? The fundamental problem is the risk of bias. The party with exclusive power to appoint the arbitrator is naturally incentivized to choose someone who will benefit them or favor them. So, this creates a perception of my judge, my jury scenario, which completely undermines the core principle of arbitration, which is fair, neutral, and unbiased dispute resolution. The challenge to this practice did not start today. The seeds were sown in the Rameshwar Prasad versus Aravali Power case, where the court suggested that a person who is himself eligible to be an arbitrator in a dispute cannot nominate someone else for that role. This was a crucial first step towards ensuring fairness. But the real shift came with two landmark judgments, Garware Wall Ropes and Perkins Eastman Architect. In Garware Wall Ropes, the Supreme Court held that if an MD is ineligible to act as an arbitrator because of his interest in the company, they are also disqualified from nominating another one for that role. You cannot delegate a power which you don't have. Perkin Eastman expanded this position significantly. The court said that this is not just about the managing director. Any clause which gives a party sole and unilateral power to appoint an arbitrator is invalid. Why? Because it raises justifiable doubts about the fairness of such arbitrator. Moreover, such an appointment would feel as if one party is imposing their choices on another. This brings us to the latest judgment, which is the railway electrification case. Here again, the contract allowed the general manager of railways to appoint a sole arbitrator. The contractor challenged this clause of the contract. The Supreme Court, reinforcing the principles from Garware and Perkins' case, delivered a clear and unambiguous verdict. A party cannot unilaterally appoint an arbitrator. That is, they cannot appoint an arbitrator without the consent or a joint decision of the other party. The court declared that such clauses are against the fundamental principles of arbitrations and are void ab initio, that is, void from the beginning. So, what is the impact of this judgment? What it means for the financial institutions and other parties who have such a similar clause in their contract? So, here are some real world consequences. Standard loan agreements often have such a unilateral appointment of arbitrator clause. Most banks and NBFCs include such a clause in their contract. These would now stand to be void ab initio. This will also affect the recovery procedures. Say, if a borrower defaults and the financial institution appoints an arbitrator, such a decision of a unilaterally appointed arbitrator now risks getting challenged before the courts. There is an urgent need for revision of all the existing contracts having such clauses and to update them in accordance with the law laid down by the Supreme Court. Even in ongoing disputes where there is a unilateral appointment of arbitrator, such an appointment may risk being challenged and set aside. So, what is the way forward? The best way is mutual appointment of arbitrators. Nothing can beat that. Another good alternative can be institutional arbitration. This could be a more robust method where the appointment is referred to a neutral arbitration institute, such as the Indian Council of Arbitration. These bodies have established unbiased rules for appointing arbitrators. Parties can include a clause which says that if they are unable to agree on an arbitrator, then they can approach the court under Section 11 of the Arbitration Act to appoint an arbitrator. If a panel system is used, then it has to be a fair panel. That means each party could nominate members to the panel and in equal strength to maintain fairness. Simply providing a pre vetted list of arbitrators controlled by one party is not going to be valid now. This judgment is a monumental and welcome step to strengthen the integrity of the arbitration process in India. This ensures that disputes are settled on a level playing field and not dictated by a party having more power. For all businesses, the message is clear. Review your contracts and embrace fairness and impartiality in your dispute resolution process. Failure to do so could render the arbitration proceedings invalid. So that's all for the legal update today. If you find this video helpful, please press the like button. And for more such legal updates, stay connected to our channel Prashad Law.